Okay, I think we can start the last panel, and the last panel is dedicated to challenges for the judiciary in times of populism, and I think it's also very challenging to keep our attention at this hour. But I have great speakers in this panel. First of all, it's ADAMSKA-GALLANT. You know her very well because she used to be very active in MEDEL. And she was also in the board of MEDEL, and she was also working in Kosovo and for Prawo Justice in Ukraine, and she was a member of Justitia. And I must say, just my personal story, we were in the contact for the first time in 2016, and actually it was Anna who made a kind of intro for me to MEDEL, and she explained what is MEDEL about. And I remember she said that MEDEL is very informal, and as you see, it is true. Then we have Professor Laurent PECH, who is the Dean of Law and head of the Sutherland School of Law, University College of Dublin. He is a great fighter for rule of law, and I must say that he was a headache for our Ministry of Justice in Poland. And he was everywhere on many occasions in Poland, in Polish Senate, taking part in debates. And I remember especially Sebastian Kaleta really didn't like you. And online, I believe there is Michal BOBEK with us. He is the judge of the Supreme Administrative Court in Czechia. He used to be Advocate General in the European Court of Justice in Luxembourg, and he also dealt with, I remember quite well, with Polish cases. It's a great honor for me to have you as speakers. Our format is just to keep your attention, just Q&A. We don't have presentations with us, so I will ask questions to the speakers about particular things. So first question to ADAMSKA-GALLANT. Relying on your experience, you used to be a judge, then advocate. Now you are a judge in the Tribunal of Human Rights in Strasbourg. What do you think? How can we keep the independence, judicial independence, in these difficult times when we face the wave of populism in Europe?
First of all, I'm really happy to be here with you. And thank you, Monika. Thank you, Maria Rosaria, for invitation. And I just want to say that MEDEL was always an important element in my professional life, in my activism, judicial and not judicial. And I think that also this, how to say, this experience from MEDEL helped me to be where I am now, meaning in the Court of Human Rights. And yeah, when we talk about the populism and the threat to the judicial independence, I think that we are really living in a very difficult time. And I must say that this is even more difficult to me to talk to you today after the election in Poland we had just 2 days ago, which seemed to be another turning point in restoring the rule of law in my country. And the meaning of this election is still not clear. And I also have to be very careful when talking about this, because for sure it will have an impact on this, how we work in the European Court of Human Rights. But I want to start from the populism itself, what it means, because we are talking about the populism, and we are talking even about the wave of populism all over the world. And it's much easier to talk about the United States and the example from there. And I believe that for many of you, as for me when I was a student a long time ago, the United States democracy, check and balance, and all judicial independence, it was like a template that we should follow. And now where we are observing this, what is happening in the United States during the second term of Donald Trump, this is something that is I think, shocking. Or, you know, with our experience from Poland, it is less shocking because we already gone through similar things in the first term of Prawo i Sprawiedliwość, Law and Justice Party in power. But you know, when we talk about the populism, this is always about this approach that is against the elite. This is like referring to the vox populi, to so-called people, to the people who believe that their needs, their expectations, their rights were disregarded, that they were violated by the elite. And it's clear that on many occasions, the populists as an elite, they see also judges, because judges are well-educated, judges are independent, judges have power, and judges, these are these people who decide. So this kind of attack of the populism is also against the elite of judges. And you know, judges need to be the elite of the society, because judges, they are to defend the rule of law, they are to protect the rights of any individual against the state, against the authorities of the state, but also in the debates among themselves, among the individuals. So judges needs to be impartial, judges needs to be independent, which means the set of safeguards that are needed to be implemented by any country that wants to be perceived as the rule of law state. But what is also very important, and what is under the attack when we talk about the populists, this is the trust. This is the trust to the state itself, to the authority of the state, and also this is the attack on the trust to the judiciary. And I believe that without trusting the judiciary, we cannot be effective. The rule of law cannot be protected if people do not trust the judges, if people do not trust the courts, if people do not trust that the judgments that have been issued by impartial, independent judge. And this is what we are unfortunately facing in Poland, that I know that you are following very closely the developments in Poland, and also the European Court of Human Rights addressed it on many occasions, the issue of the guarantees under Article 6, whether the judges who were appointed with involvement of this judicial council that has been declared as not, or recognized as not properly established. So whether these judges guarantee that people get justice delivered by independent, impartial judges. So I would say that I would connect this populism, and I think it's really a wave. It's something that is moving forward. That this populism undermines trust into the institution, undermines trust into the courts, and you know, it's extremely difficult to defend against this. So I don't know if I have any proper answer to this question, except maybe like education, like civic education, like making people aware about the importance of judiciary, independent judiciary. But then we also come to this, to what was discussed during the first panel, you know, this artificial intelligence and its impact on the right to information, on the right to freedom of election. But I think I will stop here because I can talk quite long, sorry.
And Michal, BOBEK, what are your remarks on this? You have the perspective of both Luxembourg and now of the Supreme Administrative Court in Czechia. What are your remarks?
Hello, good afternoon. Do you hear me?
Yes.
Hello. Well, first of all, happy anniversary, MEDEL, and lots of good work. Second, I shall try to keep it brief to question asked, really, and do rather a snappy answer as far as I am able, and perhaps we might come back to it in a discussion if you like. So, first, how can judicial independence be maintained in the face of political attacks on judges? Truth? I don't know. If I knew, I wouldn't be going to conferences. But well, I think I have a feeling about the direction, perhaps. And the answer is twofold, really. I mean, of course, with the caveat that it's always extremely local dependent. So local varieties are very huge, they account for variation in each of the states. However, from the top of my head, a twofold answer. First, on the structural level, I think the way how a judiciary can best withhold a populist storm and political attacks on judges, it's primarily sticking to its process-based legitimacy, okay? Not necessarily output-based or substantive legitimacy, but process-based legitimacy, meaning it remains strictly apolitical and does not intermingle with the political process and the outcomes. So in a way, the vision of judiciary, at least we in our part of Europe in the past decades, certainly shortly after the change of the regime, has been laughing at, I mean, an ideological free civil servant who is more process-oriented and is strictly policing the borders. Actually, such a vision of a judge gets, in retrospect, quite some credence because its legitimacy derives strictly apolitical, which means it can survive the next stage irrespective of who is in power. I'm certainly not urging for any cynical formalism, which is value-free and so forth. No, what I'm suggesting, or what I think at the structural level is a better recipe to withstand political pressures, it's simply not to get politicized in the first place and remaining a political guardian of the fairness of the process. So that's at the structural level. We add to it the individual level, and there, I'm afraid, in the end of the day, it will be always about personal courage. There, I really do not have a recipe. I don't think there is one, because in the end of the day, I have, in the meantime, worked in a number of institutions, some of them judicial, and I have never seen the silver bullet or whatever recipe which will require or which will provide universal impartiality independence. No, it's always irrespective of the safety and the robustness of institutions about individual responsibility and courage, because in the end of the day, any institution can be abused and misused. And when I put the two together, I think that might be a recipe how to face political attacks on judges, because from the countries you mentioned, in particular, for instance, United States, it comes from somewhere, okay? And once we all witness, for instance, remember the appointments to the US Supreme Court, how deeply biased and political they are. And of course, once the political wheel yet again turns, that's prone to attack. Of course it is, because the legitimacy, and closing here, derives from a political output legitimacy, who has been appointed and why, not from the process-based legitimacy review. So much on the first one.
So now, Professor Laurent Pech, maybe for you it's easier to answer to some questions because you are not a judge. So my question is also the same, but could you also elaborate on this, whether, in your opinion, judges are prepared for the wave of populism, and European institutions as well, and so far, have they done enough?
So thank you for the 5 questions into one, making my life very easy. Thank you for the invitation, first of all, and it's nice to be with you. MEDEL is actually one of the organizations we made legal history with by bringing annulment actions before the Court of Justice regarding Poland's recovery plan. The litigation was mentioned this morning. And I would say litigation is part of the answer whenever courts become or are being targeted by the new would-be autocrats. You mentioned essentially what courts can do. Essentially, they're dependent on litigation before them. So you need plaintiffs, you need legal professionals. But at the end of the day, sadly, the rule of law and judicial independence cannot be defended alone via litigation and courts and brave judges. At best, in a backsliding context, this is going to help you slow down the capture process. So at best, you can slow down this very dramatically, like you have done in Poland with many brave police judges, and you can make it very costly, not only legally costly, politically costly, and financially costly. At least within the EU framework, that is possible if you know how to play with the toolbox at the right time. But in a key number of contexts, actually, association of judges, individual prosecutors, or even lawyers and legal academics can do so much, if only because, let's say, for instance, legal standing rules. I'm not going to get into legal standing rules, but the broader point I'm making is that to defend the rule of law, to defend the court, to defend judicial independence, you need to create, in fact, a broader rule of law ecosystem. What do I mean by that? You need a multifaceted answer. You mentioned education, that's part of the answer. In terms of short-term possible solutions I'd like you perhaps to think about, we need to not only to litigate and bring pressure on those who have the power to actually bring enforcement actions like the European Commission and initiate, for instance, enforcement/financial processes. But you, as academics also, we are part of the response picture to the extent that part of the attacks on the court are conceptual in nature, something I didn't see when I started working on rule of law issues or judicial independence 25 years ago. No one would kind of contest the concept itself of judicial independence. I remember going to Poland and I had to answer this argument that judicial independence actually itself is not lawful under EU law. I mean, where do you begin with this? And the argument is because judicial independence is nowhere mentioned as such in the EU treaties. But this conceptual attacks is not simply about the concept of the rule of law, it's about the role of judges, what about the will of the people, majority versus minority. And this is done via fake NGOs, via fake think tanks. So I would say don't underestimate the conceptual battle. The battle of ideas is very important as litigation, and this is a short-term pressing battle. So some people like me, we do engage with this conceptual, and this is where legal academics, I think, can play a role. You have to counteract the authoritarian conceptual battle of ideas, which is actually taking place before national and supranational courts. But at least as far as EU law is concerned, this is settled following the twin conditionality judgments of the Court of Justice. In addition to civic education, I think as lawyers, we can do also something regarding, you mentioned context, and this is a key point. This is why I have been advocating for a stress testing of every national legal system in the EU. What do I mean? Essentially, you treat the national legal system the same way the ECB would treat the financial system, and you stress test the legal system. Essentially, you assume an authoritarian coup, and you try to identify what are the weaknesses in your own legal system. We have done so with a number of French law colleagues for the French legal system. So there is a template to be followed. Once you have identified the rule of law gaps and weaknesses in your system, you try to strengthen them prior to an eventual backsliding attempt. Again, this is not a magical situation, but this is going to slow down whatever attempt at capturing the system are going to be done. You need time, you need to make sure the system can resist up to the next legislative elections. That's the key. You don't want to allow whoever is trying to capture the system to be able to consolidate the capture before the next elections, because they're going to, once they're done with the courts, then they move to the electoral system. And that's a broader point also I'd like to make. Courts are not the only targets of those would-be autocrats. Judges are, I distinguish myself in my scholarship between, it's a bit depressing, but it has to be done, between primary targets and secondary. Police forces and access to the civil service. These are the 4 key kind of preliminary steps, including the media as well. So you have to capture. So once you have captured these 5 key ingredients of any constitutional system, then you move on to secondary targets, NGOs, law professors, universities, lawyers themselves. And then once the secondary targets have been sufficiently intimidated, and I'm going to make another important point, this is done through legal means, but also through informal means. And this is where enforcement, actually, I'm bringing back to the enforcement issue. The Commission is very bad at going after formal violations of the rule of law, and they are unable to address informal undermining of the rule of law. If it does not exist in a legal form, they feel powerless to actually bring infringement actions. So if you sue on the basis of, let's say, a practice, they're asking for a lot of evidence to be produced to them. Just to give you an example, not involving courts, but I was involved in trying to get the Commission to sue Hungary to bring an infringement action regarding Hungary. And we argued, the key argument is that the new legislation targeting the NGO was producing a chilling effect, they say, which could be a legally successful argument before a court. The Court of Justice accepted the chilling effect in a judicial context. For the Commission, however, to bring an infringement action, they say, we're not going to do that unless you prove, you evidence the chilling effect in practical terms. But by definition, you cannot prove the chilling effect. Another case also showing even when you have legal ammunition to use, the default setting is not to act. I'm going to conclude this because otherwise I can go on, and then I start getting angry. And then, in fact, to bring back to the discussion to judges and the Commission, I was talking with Felipe yesterday about the Portuguese judge's ruling, you know, this famous ruling. 3 years before the ruling, I went to the Commission and said, why are you not bringing an infringement action based on Article 19, paragraph 1? And they said, because he won't fly in Luxembourg. And that's not a legal issue, that's a cultural issue. The DNA in some of the enforcement bodies is always to find a reason not to actually do your work, not to enforce the law. So they were thinking about, they were afraid of losing an infringement case based on Article 19, paragraph 1(2). So the default setting is not to act unless you're being forced to act. So there is this, in addition to the legal dimension, you have also to deal with the kind of the cultural or the ethos of the rule of law guardians. So sadly, the overall picture is actually quite depressing. I've been working on the rule of law backsliding since 2010. And seems that institutions, supranational institutions especially, are unable to learn from their past mistakes, and they keep repeating the same mistakes over and over again. I'm having the same discussion on a cyclical basis, kind of the same arguments. So dialogue is back in fashion these days. I mean, that's what I was hearing in 2010, 2012 in respect of Hungary. Legal action is not the way. Dialogue should be the default setting. That explains to a large extent the mess we are in. So, but I can go on, but I'm going to stop there.
Yeah, I can only confirm because I remember discussions we had as representatives of Justitia with European Commission, and it was very difficult to convince them to launch infringement procedures. However, I remember that different approach had a little bit different approach had Timmermans, and it was easier to convince him to do so. My next question is about the importance, or is there any importance of the rulings delivered by both tribunals in Strasbourg and in Luxembourg? But there were many of them. Very important case regarding Portuguese judges, lots of cases in Strasbourg and Luxembourg concerning Polish judges. Do you think they still have impact, and what's the future of this judiciary regarding independence of judges? Anna.
Yeah, I believe that definitely these judgments that have been delivered by both courts, Luxembourg and Strasbourg, are really important to increase the protection of judges. And of course, starting from our Portuguese colleagues who brought this first case, which allowed the court in Luxembourg to underline that this independence of judiciary can be also evaluated at the level of the European Union. And this is like a condition to be a part of the European Union. But when we look at the judgments issued by the court in Strasbourg, I think what is really worth underlining is that noticing that judges are human beings and human rights of judges can be violated. So this is like another level of protection of judicial independence. And it was visible in many cases brought by brave Polish judges with the court in Strasbourg, where judges were presented the cases referring to their independence and to threats of their individual independence. Because you can be the most courageous person. You can be the bravest judge ever, but still you need institutional safeguardings. And I would say that the role that has been played by our court was really, I just wanted to underline, has been really very important. And then we can multiply examples: Grzęda, Tuleja, Żurek, Fisek, Ozimek, Baka, the first one, important case against Hungary. And I need to say this because Rafał was involved actually in all, I believe, in all Polish rule of law cases. So he has contributed significantly to establishment of the standards of protection of judges as human beings. And this is what I often underline, that I was working in Ukraine also for a very long time, and I was especially underlining it in the context of judges as human beings, judges who are dealing with war crime cases. I see Filipa, he was also with me there in Ukraine few times, so we had opportunity to work with Ukrainian judges to underline also importance of this human rights for them. Thank you.
Michał Bobek.
Thank you. Importance of European court judgments in safeguarding independence. Perhaps a too late answer, okay? The importance is great, but perhaps more on the moral and legal level. Let's be pragmatic about the real impact on the ground, okay? But I say it full knowledge of it's extremely important in moral and legal terms as showing it's right and wrong. Because, and it's also for the first time in the history in our region, Central Europe, where there is such a robust institutionalized external support, which is continuous, okay? That's new, that's really new when we look into the history of our region, and unfortunately, the histories of our backsliding are numerous. It's always just a temporal element, whereby, of course, something is going under, something new and often ugly is being born, and it's a question of time before there is a takeover. But when that happens, the system resets itself under the new masters. Here, however, within the last 10 or 15 years in Europe, and with the member states being anchored both within the Council of Europe as well as the European Union, it's really a game changer from the point of view that there is an ongoing, continuous external support. And that's extremely important, okay? And we have never seen it before. Of course, the second point here, it's more on the pragmatic level, because of course, at least what I have been watching, for instance, cases I was involved in Luxembourg, both with regard to Poland, but also to Romania, for instance, their national implementation is perhaps, well, there are some elements still lacking. But of course, that's part of the game. If you've got a hijacked state and the power, then of course you are just feeding the moral authority to the dissidents, and the change or the actual implementation might be a matter for later on. So it's for primordial importance, even in face of often lacking execution. And by the way, as a short footnote, I very much love the LAURENT's institutional stress testing in France or wherever else, and the individual steps how to take over a system. Reminded me of a Netflix series I recently watched, Late 9, which is to how to become a dictator in 10 lessons, okay? And it's quite along the similar line of, hey, first you take over the media, then you look at the courts, then you oppress that, and so forth. Of course, Laurent, it's just a bad joke, but it's certainly something worth watching. Thank you.
And Laurent, because we know about verdicts delivered by European Court of Human Rights and court in Luxembourg, but could you elaborate on something what you already mentioned? I mean, the annulment actions and their role in fighting for guarantees of independence of justice.
Before answering the question about annulment actions, you might be interested by the guide I wrote with a PhD student of mine last year, which is, I believe, the first guide aimed at applicant judges, what I call applicant judges, essentially when they are the subject of disciplinary measures, formal or informal measures targeting them. Essentially, the guide explains to judges or prosecutors, the EU and the ECHR legal avenues with all the potentialities they open, but also all the kind of the shortcomings and the procedural difficulties they bring. This guide was commissioned and published by CELI in Prague. So if that might be of interest, I believe this is the only one-stop shop guide available to judges and prosecutors when they're being targeted by their government or the local National Council for Judiciary. He explains in practical terms, essentially, to what extent you can rely on the case law of both courts and or whether you can actually reach the Court of Justice or the ECHR or both at the same time. And essentially, it should be of interest to judges as applicants or eventually as defendant, depending if you're talking about national legal proceedings, and their legal teams. In my experience, when I talk to national lawyers defending judges or prosecutors, they're either good in EU remedies or they're good in ECHR remedies, but normally they rarely are able to connect the two dimensions together. So I think this guide could be very helpful. It's 100 pages, and in the annexes, you're going to have two tables, the key judgments and the key interim measures adopted by both courts since the Portuguese judges and the Icelandic judges. That's the kind of the equivalent in the ECHR system. And actually, the growth of the case law is nothing but amazing if you think where we were, let's say, at the start of the so-called rule of law crisis. Roughly, we're talking about 70, 75 ECJ judgments and orders on the basis of Article 19, the principle of effective judicial protection, Article 19, paragraph 1. And we're talking about this roughly the same number, actually, 70, 80, as far as the Strasbourg Court is concerned, if only because the Strasbourg Court also for the first time, and a very welcome development, started adopting interim measures essentially to protect Polish judges. So I think at some point we reached close to 25, 30, I can't remember, I struggled actually keeping track at some point. So the growth of the case law is amazing, to be welcome. The use of interim measures by the Strasbourg Court, especially welcome. The problem, and this was mentioned, in fact, previously, we're seeing increasing non-compliance because the case law has become so protective of judges and prosecutors. Then those violating the rule of law are left with no option, either to openly violate ECHR and EU law and or the case law of the Court of Justice and the Strasbourg Court. From an EU law point of view, I've seen there is a new dimension in terms of non-compliance, which I think is not sufficiently talked about. It's not simply that relevant governments are going to ignore infringement judgments. What they do also, they're targeting judges who send preliminary ruling requests to the Court of Justice. And by the time you get an adverse judgment or judgment essentially finding de facto that whatever national law has been questioned is actually not compatible with EU law, then they're going to target the judges who have sent the questions and make it impossible for them to apply the judgment in their national legal system. You have different ways of doing this, formal, informal ways. But I think the Commission has not sufficiently paid attention. Again, I'm coming back to the guardian of the treaty, to the situation of the brave judges also, not simply those bringing cases, but bringing questions to the Court of Justice and what happens to them while the case is pending in Luxembourg. And I think the Court of Justice also should pay a bit more attention. I know it's not easy to do that, at the implementation of the preliminary ruling and what happens also on a personal basis, professional basis, to the judges who have to apply. I can think, we don't have time, but I've seen very vicious actions taken against Polish judges submitting questions to the Court of Justice, not about their own situation, but about so-called reforms. Which actually we should never call reforms, we should call them changes. So I think that's my phrasing suggestion to the Strasbourg Court and the Court of Justice. Stop using reforms to describe what are changes, in most cases, unconstitutional, incompatible with EU law, and incompatible with the ECHR. By describing them as reforms, you automatically give them a positive connotation. When it comes to annulment action, I've mentioned infringement actions in EU law, preliminary rulings in EU law. Annulment action normally was not supposed to be used to defend the rule of law because normally most of the damage was done, at least until recently, by national institutions. An annulment action in EU law can only be brought against EU institutions. I'm not here to give a lecture on annulment action, but my point is, MEDEL was forced to bring an annulment action in a specific context, the Poland's recovery plan. Nothing against, obviously, Poland as such. It's just the rule of law milestones included in the Poland's recovery plan, according to some experts, and in the agreement. And there was also the assessment of MEDEL and a number of associations all represented today. We thought in this case here, we have an example of the Commission being complicit with an attempt, I mean, not an attempt, actually, with being complicit with the Polish government to actually disregard the case law of the Court of Justice. I think on the substance, our case is bulletproof. Just a concrete example. According to the Commission, it's fine to force a Polish judges who has been unlawfully suspended to initiate a new legal action to be unsuspended, even though the court has said any suspension is unlawful per se and does not produce legal effect. So the Commission is saying that's not true. In fact, it does produce legal effect, and you have to undo the legal effect by going before a court, which is actually not even a court, according to the Commission itself. I can go on and on about the awkward aspects of this. The problem is that for a number of reasons, but essentially, historically speaking, legal standing rules for non-privileged plaintiffs, including associations and association of judges especially, these have always been strictly interpreted, but our key argument is you have to face up to the new reality. You cannot use a legal test from the 1960s in a context where you don't have infringement actions because the Commission is not treating the rule of law and judicial independence as a bargaining chip. And I can mention Romania, I can mention Serbia, I can mention Turkey, I can go on and on to give you an example where the guardian of the treaty is just looking the other way. So if we don't see infringement actions, and if the judges cannot submit preliminary ruling questions, then we don't have a complete system of remedies as per the case law of the Court of Justice. In fact, the complete system of remedies has never existed, but let's not don't get me started on Lever assessment of the EU system of remedy. So our key argument before the court is essentially you have to adjust the legal standing requirements to allow association of judges to bring annulment actions when in fact the EU is complicit with violations of the rule of law, perhaps since we are between us. I was asked once the question, why is MEDEL bringing an annulment action? Why are the association bringing actions rather than simply the Polish judges subject to unlawful suspension? But what people don't realize is that our Polish judges, the ones unlawfully suspended, were getting a death threat every 60 minutes. Can you imagine having them on the paperwork being seen as or being presented as the obstacle between the country receiving 26.5 billion euros. So this is why we decided to bring annulment action from this was kind of a strategic litigation, a brainstorming. We decided to bring the annulment actions through the European Association of Judges, and not even the National Association of Judges, to prevent smear campaigns targeting individual and national associations. And if the annulment, if this annulment route is not available, then essentially you face an accountability gap where the EU can freely, without any legal consequences, essentially let the rule of law or just being complicit in the process of dismantling the rule of law, which we have seen has been done in a number of countries for reasons of political expediency and geopolitical reasons. In the recovery plan, just that's not a well-known fact. The Parliament could have brought a case. We would not have been able, then it would have avoided annulment actions by association of judges, including MEDEL. But the Parliament refused by one vote in the committee, and that was the vote of the decisive vote against suing was a vote by a Polish opposition MEP on political grounds. But again, it shows that you need to expand legal standing. You cannot have the rule of law enforcement left at the mercy of political discretion or political considerations. Otherwise, the situation is going to get worse. Now, the MEDEL and all case is pending before the Court of Justice. We are making an additional argument, which was not available to us before the EU General Court, to take into account the climate change litigation of the Strasbourg Court. You'd be pleased to know, again, based on the confidential submissions I have access to, the Commission and the Council are saying, I'm summarizing, We don't care about the rule of law case law, the climate change case law of the Strasbourg court, because first of all, the EU is not yet a party to the ECHR. Plus, in any case, even if he was a party to the ECHR, we wouldn't care either because of the autonomy of the EU system of remedies. So the rule of law only important to the extent that it's convenient to us, but when it might lead to actually a change in legal standing, no. Then autonomy prevails over the rule of law. That's my understanding of the submissions. That's not the court's position. That's the submissions by the Commission, the Council, Poland and Hungary, and I might be forgetting someone. But it's interesting to see the contrast between the confidential submissions and what politicians are saying in terms of EU accession to the ECHR. If I could publish them, but I can't, it'd be interesting to have the public statements regarding EU accession to the ECHR and then the legal submissions regarding whether you need to take into account legal standing related case law of the Strasbourg court. And then obviously it means that there is very little appetite to adjust the annulment action. So we'll see, watch this space. We don't quite know whether we're going to get when the next step is going to be. We're hoping for a great advocate general. Sadly, some of them have left the court already, but we're hoping for a great open-minded advocate general to be appointed and then possibly to kind of hopefully side with MEDEL and the other associations. There is another pending case raising, by the way, the same kind of arguments, and that's also a first in the history of EU law. An annulment action brought by Romanian Association of Prosecutors. Also, I was involved in this case, just putting together the lawyer for the key senior counsel for or the MEDEL in all cases, the same for the Romanian Association of Prosecutors. Annulment action, this time targeting the Commission's decision to repeal the cooperation and verification mechanism. Again, on the substance, I mean, you can never be 100% legally confident, but I would say we have a very, very strong case that the treaty itself was not complied with, even procedurally speaking. But then legal standing was also denied by the General Court on the basis that Romanian prosecutors have no direct concern when it comes to the closure of the cooperation verification mechanism, even though it does include actually legally binding rule of law benchmarks. And it doesn't matter, according to the General Court, that Romanian prosecutors and judges are actually involved in the assessment of the rule of law situation in Romania. The EU General Court also, I'm not here to criticize court, but sometimes, you know, you have to do that in a polite way. But I would say the EU General Court in this instance also completely disregarded the Commission's own rule of law assessments regarding the situation of Romania. And then actually back to my political discretion being abused by the Commission. The Commission used reasoning to justify the closure of the cooperation verification mechanism, which was in direct contradiction to the findings of the Commission in the Romanian country rule of law report of the same year. So you read one decision, everything is fine, and then plenty of serious concerns about the rule of law situation, but happy days, since no one can actually sue us through an annulment action. So that's it for me, sorry.
Thank you so much. And just to underline the case Laurent was referring to was also brought by other associations. There was Judges for Judges and European Association of Judges and Administrative European Judges Association. And it is an example of great cooperation between the European associations and foundation. And the last question, because we don't have much time now, do you feel that populist sentiments have any impact on the functioning of European courts? And what are the main threats? I mean, there are two questions, and maybe something optimistic, please, at the end, Anna.
I'm too short to feel the pressure. No, I don't feel the pressure. But of course, I see this threat from the populism on the rule of law and democracy everywhere. This wave is really visible, and when it comes to European Court of Human Rights and the European Convention on Human Rights, we always say that this is the living instrument, so that we need to adapt to the context, to the changing situation, but of course within the limits that are determined by the fundamental rights which are prescribed in the convention. And I believe that of course there are politicians who expect some, how to say, changes in the approach, but this is only thing I would say. I would close now, not to comment more.
Michał, BOBEK.
Thank you. Just to be clear, by European courts, you mean the Court of Justice in Luxembourg and the European Court of Human Rights, right?
Yes.
Okay.
But maybe you can also share with us your perspective, your Czech perspective.
I can try sharing both, but look, at the European level, I don't think there is any impact or pressure, simply for the very simple reason that both of the courts are, in the way their members are at present appointed, very robustly protected, which is yet again a unique system which comes with pros as well as cons, okay? When you look at the Court of Justice in Luxembourg, then of course any national nomination before it is confirmed by a common accord of the member state has to go through the so-called 255 panel, which is composed of 7 personalities chosen from mostly former members of the court and national senior judges. And they act as a very robust safeguard against any populist appointments. Of course, then the backside of that is we have protracted vacancies, because of course we all know the example of Poland, where Nina Poltorak, the judge at the court of the General Court, has been sitting without a formal mandate on the court, the General Court, longer than many members having a formal mandate, because of course of the government which didn't nominate. And of course there is, for instance, now vacancy following the departure of Marek Safian, who couldn't or wouldn't longer sit, so there is no Polish judge. So similarly at the level of the Strasbourg Court, of course, with the bifurcation of the panels of the council and then the advisory body of the Parliamentary Assembly, there really, I mean, the courts, both courts are very well insulated from potential populist takeovers, okay? And this is quite unique because, of course, with such bodies in place, what we are likely to face in immediate future are possibly protracted vacancies or former members who would be appointed before the populist government take over in their member state, simply sitting on the mandate until the successor is appointed, which can be for a number of years, actually. So that's the good news. And just complementing, since you asked me at the national level and the populist sentiments and pressures, of course, there it's much more visible and it's much more seen because, of course, you don't have such external or direct external and impartial safeguards or not as much visible. And actually the most intriguing example, just to conclude on that, because I understood this is supposed to be a question and answer session, was when we look at what has happened to constitutional courts in a number of Central and Eastern European countries, okay? Think 20 or 30 years back, when we all eagerly adopted the blueprint of going into the destination of rule of law, and part of the institutional blueprint was, oh, you must definitely get a constitutional court. Then, of course, your future and bright protection of constitutionality will be protected. Now, of course, what we see, what happened later on, and now actually we see the contra movement, hence populist rising and populist pressure on courts, because of course we also saw very recently in the last decade, then if one puts in one super powerful institution within the constitutional setup, then coming back to Laurent and his stress test of national institution, that's the weak spot, okay? Especially if you are running a constitutional court style Karlsruhe, which is omnipotent and unifies all the state power and can effectively review the executive, the legislature, and the courts. Then actually, if you are looking at robustness of institution and populist pressure, we all know which was the institution in Poland, which was firstly dismantled and very quickly. So, sorry, last marching order, you said something popular, sorry, populist, popular, no, sorry, popular, optimist, sorry, that'd be long. Concluding on something more optimist, actually, the future And the robustness of institution there lies in something which shortly after 1989 in other parts of Europe, we were laughing at and we thought must be corrected and must be educated. Ordinary courts. Because what we see throughout the region, it's very easy to take over one constitutional tribunal overnight. It's much more difficult to start controlling diffuse ordinary judiciary and above all first instance courts and courts of appeal, okay? And that's really where the robustness of institution lies, certainly for the future, after the renewal and the really coming of age of ordinary and in particular the lower courts.
Thank you so much, and especially for these words about the ordinary court. And Laurent, you have 5 minutes, please, now to conclude and about the future of judiciary in Europe facing the populism.
I can be short. I just wanted to mention something, a new development, which is actually a bit worrying because also it is not counteracted by the guardians of the rule of law with legal actions. We are seeing a growing number of state-sponsored smear campaigns targeting courts, individual judges, but also family members. I mean, not exactly new, but I can see a growth and a strategic and systemic use of social medias, and we're seeing that the latest example actually is the US. I don't know if you've been following the news, but there was a recent investigation by Reuters regarding the threats targeting federal judges, and they found at least 11 examples where family members of federal judges were specifically targeted by members of the Trump administration, plus the owner of the so-called X network. Actually, meaning, I would say, all the courts should leave X because this is a network being used to actually incite to hatred against judges and courts. So we're seeing smear campaigns, but in the US, this was not the first example. In Poland, they actually went further. They had a so-called troll farm within the Ministry of Justice. So actually the state was paying officials to populate social media with messages, essentially, to threaten, intimidate, create, again, a chilling effect. MONIKA, I believe you were targeted by this troll farm. And yet, what did we see? Not a single legal enforcement action against Poland, even though we have evidence of a government having a dedicated administrative unit whose job is to intimidate judges and their family on social media. For me, that's a clear-cut violation of the principle of effective protection. And I would say, in fact, this is where there are many gaps actually in the case law, but I would say it'd be great to see an enforcement action where going after a smear campaign where there is evidence of state involvement and then arguing that EU member states have a positive obligation to protect the rule of law and not simply a negative obligation to react to violations of the rule of law. And then you go after EU member state inaction when judges are targeted on social media. As a matter of EU law, private action falls within the scope of an infringement action. A member state cannot say, well, I'm not responsible or liable for private actions. In this case, actually, it was the de facto the state anyway, in the Polish troll farm case. But I would say we need to get our heads around what to do when individual judges, prosecutors, associations are targeted via social media. And usually the ruling party is smart enough not to do this by using state resources, but what they're going to do, they're going to subsidize private actors, and then the private actors are going to do the dirty work. But I think this is still a violation of EU law, and I would say you could also bring an ECHR case if you're an individual judge targeted. You bring domestic proceedings, blah, blah, and you're going to argue that there is a breach, or you could say privacy, family life, especially when your family members are targeted, and you're going to argue a breach of the duty of positive action in the face of the lack of the ruling party and the state to actually remedy smear campaigns. This is actually not simply used against judges, but in fact, some of my colleagues have been also targeted. Well, I would say myself also, I got my fair share. So they also target individual academics depending on your subject matter as well. So smear campaigns are now a new tool of the autocratic playbook. Now, some good news. You wanted some optimism. Now, first of all, I would say, from a personal point of view, the best it's not the best, let me backtrack. Positive indirect consequence of working on rule of law backsliding is that I got to meet great people like you, Monika. And I know now more about Poland than I ever knew I would know. And more broadly, I think he has brought legal professionals together. I think judges, lawyers, scholars, at least working on judicial independence, we work more as a community like that was the case 10 or 15 years ago. Another positive and direct consequence of being targeted by the same would-be autocrats. I think there is kind of a sense of transnational solidarity between judges and national judiciary, which I didn't see 10 or 12 years ago. So the MEDEL in itself was a precursor, but I think there is a wider understanding that when the rule of law is undermined anywhere in the EU, it is undermined everywhere. So what happens in a specific country will have knock-on impact, and this is why we need solidarity just across the legal professions. So that would say that would be the positive. And then one last aspect, there is an autocratic playbook, but there are now also anti-backsliding playbooks. So we should not give up. We should keep up the fight, and we should stay strong because the rule of law needs you. That's it for me.
Thank you very much. It was very interesting discussion. I hope we managed to keep the temperature of the conference till the very end, before the very, very end dedicated to our Turkish colleagues. And indeed, we are definitely not going to give up, and MEDEL is the best place where we can keep our values and fight for them. Thank you so much.